for the anxious client, the Georges of the world, sometimes it's easier just to file it and be done. And if you choose not to, then it's important to keep your finger on the pulse. I don't know if you've heard, in November we elected a new president. He took office in January. So there's a new administration.
I've heard
Does that have any impact on the Corporate Transparency Act?
Yes, it seems to have had an effect on the Corporate Transparency Act. First off, though, just a little history. The Corporate Transparency Act was passed and required small business owners, private business owners, to register with the government who owns the company. They're trying to look into money laundering and criminal activity, and they passed this law saying, and we discussed that on other podcasts, but there was a series of cases that confused everybody about whether or not the Corporate Transparency Act was going to be enforced.
Days of our laws.
That's right.
On again, off again.
We were getting emails every other week.
Will they, won't they?
Right. It's on, national stay, they won't enforce the law, then that stay gets lifted by another court, then another court comes in. It was very confusing, and for a period of time there we had no idea. It's on again, it's off again, it's on again, it's off again. Then, new administration comes in, and the new Treasury Department says, we're not going to enforce the law except against foreign companies. Now, this is from the Department of the Treasury, presumably the agency that's going to be tasked with enforcing the law. However, that's not a law, so we're kind of stuck in this limbo land where, the safe course of action, I think, is to continue to make the filing. But what do you think?
I agree. The safest course is to do the filing. I have certain clients, let's say, let's call one George. Okay, George calls me about Vandelay Industries. George is very anxious.
The Costanza file.
Yes,
I've worked on that one too.
With that one?
Yeah.
Okay. There's a multi-generational trauma here, but let's leave it with George.
Okay.
George has Vandelay Industries. He's the beneficial owner at this. There's no other employee. There are no other owners. Just him, because it's not a real company. But it was formed as a company.
Sure.
Okay. So according to the state of New York, it is a company. He needs to file a beneficial ownership report. He doesn't want to. He doesn't want the federal government having his name attached to this company. So every time that there is a deadline, when it's on again, I get a call from George, a very harried call, and he's very concerned and he wants us to file. Then he'll tell me, but wait, don't file it until the day before this deadline. I don't want to file too prematurely because it may be off again. Mm-hmm. And lo and behold, it's off again. And then I hear nothing from George for quite some time. A couple months pass, it's on again, new deadline. Guess who calls? George.
Okay.
George calls, says, okay, same deal, day before filing, I want to file. And then it's off again. And we do not file. So George is left hanging because of his general concern about having his name in this registry, which I can understand, and he doesn't want to file. So we're holding George in a holding pattern until he tells us go.
Right.
Kramer, on the other hand, are you familiar with the Kramer file?
Kramerica, I believe.
Kramerica Industries.
Yes.
Kramerica, he is a lot more comfortable having his name in the file. So the first time that there was a deadline, he told us, yeah, here's my info, file it. We filed it. Kramer goes on to do whatever he does with the rest of his time. He never worries about it again, but his name is in this system now. So if Kramerica ever gets triggered into any sort of money laundering scheme, if their name comes up, or a counter-terror issue, their name comes up, they can trace it back to him, and perhaps in some future episode, there's a knock on the door of Apartment 5E, or 5A, or 5F,
right?
And Kramer.
Well, I don't doubt that Kramer's not doing anything illegal. It's just no one knows what he's doing, right? So I think he'd be okay. Now, one question I think people still don't understand is that when Kramer brought on George's dad to sell the Manzier, or Bro, did that trigger a need to update the filing? So, if I recall correctly, Kramer's dad was not an officer of the business. Mm-hmm. He was not an owner of the business. He was
an employee of the business.
Yeah. They could have been
Important.
partners. Right.
So if he rose to a C-level position, when he was out on the sales trail, he became chief revenue officer, and he is driving critical business decisions more than just trying to sell the bro, but also deciding whether they should acquire a competitor or adding significant new lines of business or new employees. He might rise to the level of substantial control, which would trigger him being included, needing to be included in the beneficial ownership report. And what's interesting about this is that from the moment that he rises to that level of substantial control, there's 30 days to file it, an update. Even if Kramer filed on time,
Right. The first time.
a year ago,
Right.
new change means new filing. So I mean, we haven't seen a lot of updated filings yet. I've seen them in the course of acquisitions and changes of ownership, but I haven't really seen them in terms of changes of substantial control in this way.
But you know what I mean. But no doubt clients are going to hear that the CTA or the Corporate Transparency Act is not going to be enforced by Treasury and decide I'm just not going to do it.
Right.
I don't want to pay you to do it. I'm not going to do it. And that's certainly their decision.
Right.
It's just I would say that carries with it the risk that
It's just hanging over you over time.
And we'll lose track of it or we'll forget about it.
Right.
And a future administration might not take that position.
Right, that's right. Every time that we've seen that it comes on again, Treasury and FinCEN have been good about giving 3 or 4 weeks notice before a new deadline, and they've been good about not holding it against a non-filer for this time period that it was off. However, that is a decision, and that, like any other administrative agency, they can just from one day to the next change it. So to your point, I think for the anxious client, the Georges of the world, sometimes it's easier just to file it and be done. And if you choose not to, then it's important to keep your finger on the pulse.
Right. Set a Google alert. Do something
Right.
to see what's going on there. So
there is one other note that, believe it or not, there was a unanimous bill in the House, 408-0, to extend the CTA a year to January 1st for all of those entities that existed before January 1st, 2024. They would have until January 1st, 2026 to file. And it's sitting in the Senate now, so we'll see if that makes it all the way through to law.
unlike the public stock market, which is updated every hour, every minute, and you can kind of see what the trends are happening, and there's some long-term forecasting and things that are a little more refined for that. With the private market, there are also cycles, and what we see are cycles of entities having excess cash available to do deals, low interest rates. There are periods of time when there is increased private market activity, which creates demand for sellable businesses, improves multiples, improves the potential purchase price that someone could sell their business for. And then there are downtimes when interest rates are high, people are holding back their cash, and if our client finds themselves in a position where they're ready to sell at a low time of the market, we might counsel them like, look, this isn't the best time. Let's wait 12 months.
Right.
But you know, I'm not the we're not economists, regretfully.
Speak for yourself.
Hey, oh, you are, aren't you?
No.
Oh, okay.
I just don't want you to speak for me.
Okay, fair enough. But we're talking to other advisors out in the community and who have some knowledge about that, so that we can help prepare our clients for the right time.
Right. I mean, the other factor here is that, for every buyer there's a seller, and for every seller there's a buyer. So, if there's a deal, it's because the interests align where one, it feels that they're in a better position if they exit, and another feels that they're in a better position if they acquire. So the deal flow is where we see the ebbs and flows, but whether it's more advantageous to buyers or sellers may not have anything to do with the broader economic situation. It may be that in an individual's case, it's in their best interest to sell, even though their deal flow is slow and interest rates are higher, and all of these factors. And for the acquiring entity, the same in reverse. It may be in their interest to acquire for longer term reasons. They want to get this into their portfolio now. Time is of the essence on expanding their offering, or however they want to grow, and this is the opportunity they've been waiting for. So
there's also industry cycle too. I mean, the broader economic picture is fine, but certain industries, whether it's construction or technology or whatever, I mean, they see their own sub-cycles in there as well. Right now, a lot of clients investing in data centers for AI. We're seeing a lot of, I have a number of general contractor construction clients building data centers all over the place, bidding for them. They're going up like crazy. Those are extremely computer and power intensive. So, everyone's out there scouting locations to build data centers, and then we have certain clients that have expertise in that, so
yeah.
Hot, very hot right now.
Time to go delete those old texts that you never want to see the light of day.
AI is another topic that is big. I know that our firm hasn't really spent a lot of time investigating AI tools to help our business. I think we're still a little skeptical of it. Every other large company and giant professional services firms is looking at it and to see how they can more efficiently provide services to clients. I feel like our practice is more personally tailored and bespoke to certain client interests and stuff. And while AI might be a tool, we're still pretty much AI free in terms of our document generation and work product compared to other firms.
Yeah, absolutely. I mean, the nature of the research side of our operation, I think, is much more tailored. At a bigger law firm that's assisting, a Fortune 500 client, they likely have volumes of research that are common among those clients that might justify investing in this sort of technology to bring efficiency to that process. They're also reviewing, far greater numbers of documents in pure volume that
Sure.
might support.
Especially, document reviews and due diligence
Right.
and that type of stuff, yeah.
In our case, when we're making a rep and warranty that there has been no litigation, it's a phone call to the client that takes about 10 seconds, and if they are concerned about it, maybe it takes 5 minutes. I'm not sure that we're in a position with the nature of the transactions that we're assisting with that AI would play a big role for us.
No.
But did you see those ones where you have first and second year associates at the big law firms turning to AI and AI inventing cases to support a position?
Yeah, I mean, it's that's the thing about it, right? It's still kind of untested, unproven, and I suppose one reason I brought it up here was to give our clients assurance that we're not heavily reliant on it. It's almost like advertising GMO free food. You know what I mean? Like we're not, we're going straight to the source. We're not using AI to invent our
Right.
research for us or draft our documents for us.